Welcome to Law Made Simple. In this video, we're going to discuss a very important topic: how to get a stay order from court in both civil and criminal cases. A stay order is a legal tool that can pause court proceedings or stop the execution of an order. This can be crucial when you are appealing a decision, facing enforcement of a decree, or seeking to prevent an action that could cause serious harm. We will cover what a stay order is, when it can be applied for, the legal provisions that govern it, and the exact steps you should take to get one. By the end of this video, you will have a clear roadmap that you can follow in real-life situations. So, let's begin and break down this process step by step. Introduction: A stay order is essentially a protective shield granted by the court to temporarily halt a legal process. It gives you time to prepare your case or wait for a higher court to decide on an important issue. Many people believe stay orders are only for large, complex disputes, but they are also used in everyday matters like property disputes, check-bounce appeals, and even certain criminal cases. The main idea behind a stay order is to prevent irreversible harm that might occur if the proceedings or judgment were carried out immediately. In this video, we will guide you through the complete process, from understanding when you should apply, to knowing which court to approach, and how to present your case effectively. With the right preparation, a stay order can be one of the most powerful legal protections available to you. What is a stay order? A stay order is an official direction from the court to pause legal action temporarily. There are two main types: a stay on proceedings, which stops a case from moving forward, and a stay on execution, which prevents a judgment or decree from being enforced. The reason courts issue stay orders is to make sure that no party suffers harm that cannot later be undone. For example, if a property is about to be demolished while an appeal is pending, a stay order could prevent that until the final decision is made. It acts as a safeguard to protect legal rights while the court fully considers the matter. Without a stay order, you could face actions that might be very difficult or even impossible to reverse later on. When can you apply? There are several situations where you can apply for a stay order. One of the most common is when you have filed an appeal against a lower court's decision and want to stop that decision from being enforced until the appeal is decided. You may also apply when urgent action is needed to prevent harm, for example, to stop an eviction, demolition, seizure of property, or arrest. Stay orders are also used in situations where a higher court is examining the legality of a proceeding in a lower court. The key point is urgency. You must act quickly before the damage occurs. Courts are more likely to grant a stay if they see that waiting for the normal process could cause serious and irreversible harm to you. Legal provisions: The law clearly defines the provisions under which a stay order can be granted. In civil matters, Order 41 Rule 5 of the Civil Procedure Code allows a stay during an appeal, and Order 21 Rule 26 deals with staying the execution of a decree. In criminal cases, Section 482 of the Criminal Procedure Code gives the High Court inherent powers to prevent abuse of process and to secure the ends of justice. Section 389 of the CrPC allows the appellate court to suspend a sentence pending appeal. Quoting the correct section in your application is very important because it shows the court you understand the legal basis for your request. It also helps the court process your application faster and with greater clarity. Step-by-step process: Here is the step-by-step process for getting a stay order. Step 1. Consult an experienced lawyer who can assess the urgency of your situation. Step 2. Prepare a detailed application or affidavit that clearly explains the facts, legal grounds, and reasons why a stay is necessary. Step 3. File the application in the correct court, whether that's the trial court, appellate court, or high court. Step 4. Ensure a copy is served to the other party, as required by law. Step 5. Attend the hearing, where your lawyer will present your arguments and evidence to show why a stay should be granted. If the court is convinced, it may issue an interim stay, which will last until a final decision is made on your application. Essential tips: To increase your chances of getting a stay order, you need to meet certain legal tests. First, show that you have a strong prima facie case, meaning that at first glance, your claim appears valid. Second, prove that you will suffer irreparable harm if the stay is not granted, harm that money alone cannot fix. Third, demonstrate that the balance of convenience is in your favor, meaning it is fairer to maintain the status quo until the case is decided. Always act quickly, as delays can weaken your case and suggest that the situation is not truly urgent. Supporting documents, such as copies of the judgment, appeal papers, or evidence of harm, can also strengthen your application. Remember, preparation and timely action are key to success. Duration and limits. A stay order is never permanent, it is meant to be a temporary measure. In most cases, it lasts until the case is decided, or for a specific period set by the court. The court has the power to extend, modify, or cancel the stay depending on developments in the case. Sometimes, the stay may be conditional, requiring you to deposit a certain amount or fulfill other requirements. If a party misuses the stay order or causes unnecessary delay, the court can impose costs or penalties, and even vacate the stay. That's why it's important to use this legal tool responsibly and only in genuine situations. Conclusion and call to action. To sum up, a stay order is an important legal safeguard in both civil and criminal matters. It can prevent injustice by pausing proceedings or stopping the enforcement of a judgment until the case is properly decided. If you ever need to apply for one, remember to act quickly, choose the correct legal provision, and present a strong, well-documented case. Getting a stay order is not just about filing papers, it's about convincing the court that justice requires holding things in place. I hope this guide has made the process clear for you. If you found this video helpful, please like, share, and subscribe to Law Made Simple for more easy-to-understand legal guides that empower you with knowledge.